Sharing data with third parties can create real legal risk for organizations. And while it may be challenging to find a specific law that prohibits that third-party data sharing, there is an emerging class of plaintiffs' attorneys that are looking at those and assessing whether they meet consumer expectations, assessing whether they meet the exact promises found within a privacy policy, and looking for those cases that will not only reap a settlement or a judgment, but also put pressure on organizations due to the brand damage, due to the protracted nature of litigation, due to just that messy process that litigation creates for organizations.
You know, Ben Franklin once said, paraphrase loosely, 3 people can keep a secret if 1 and 2 are dead. And the reality is we're not prepared to get rid of 1 and 2 in order to preserve those secrets in this country. So we have to come up with ways where it's not so much the act of sharing that creates liability or risk, but rather the use of the information and how it's misused. We all know that when you share your confidences with your doctor, that leads to more sharing of information. If we didn't think we could share with our doctor responsibly, we wouldn't, and we'd get worse health care. It's the same with lawyers and many other fields. What we need to try and reach a consensus and figure out as business people and consumers is how to best do that, because we know that when we have privacy, when we have security, and when we have trust, consumers will share more information. And what we're seeing today is the sharing of information delivers tremendous value, not only to the American economy, but to individual consumers. The reality is we have so many free services today that we wouldn't have and couldn't have if there wasn't some kind of information sharing going on behind the scenes.